I'm Michelle Jernigan, and I just want to welcome everyone today to our webinar. And I am a mediator and arbitrator with Upchurch, Watson, White, and Max since 1992. I became a mediator in 1988, and I became a qualified arbitrator in the 90s. So I've mediated thousands of cases to date in the areas of employment, personal injury, property damage, insurance, ERISA, and complex commercial. I've also arbitrated probably 30 to 40 disputes, binding and non-binding. I'm an emeritus member of the ADR section of the Florida Bar. I serve on the board of the American College of Civil Trial Mediators, and I'm a frequent lecturer in the field of ADR. I also have with me some friends and colleagues and an esteemed panel for this presentation today. So first I'm going to introduce Lawrence Kolin, who brings parties and counsel together to settle difficult cases by mediating lawsuits in state, federal, and appellate courts. He's successfully mediated thousands of matters, including multi-party and complex civil cases of all types, since 2001. Lawrence formerly served as a general magistrate in the 9th Judicial Circuit of Florida, presiding over hearings and bench trials. He's also experienced in conducting arbitrations as a qualified arbitrator dating back to 2005. He's an AV-rated preeminent super lawyer who has practiced law as an advocate for plaintiffs and defendants in diverse areas of civil trial work, and he was a partner at a statewide law firm. Lawrence led the effort to incorporate electronically stored information into Florida's civil procedural rules. He was founding chair of the ADR committee of the Orange County Bar and serves as an executive council emeritus member of the Florida Bar ADR section. He's also author, I didn't know this about you, Lawrence, you've been keeping secrets. He's also author of Orlando Mediator Blogspot.com over the past dozen years, where he shares his thoughts on trends in ADR. Our next panel member that I'm going to introduce is Christy Foley. Christy's an attorney mediator who's licensed to practice law in New York and Florida, and her legal work focuses on contracts, intellectual property, and business disputes. In 2018, Christy founded eMediation Services and began providing virtual mediation services to parties. As far as I know, Christy was the first person to offer that type of service in the state of Florida. Christy currently serves as the chair of the Florida Bar's ADR section. She's also chair of Florida's Mediator Ethics Advisory Committee, and she's the director of UCF's Conflict Resolution and Analysis Graduate Certificate Program and the coach of UCF's mediation team. Last but not least, I wanted to introduce to you Christina Magee as one of our panel members. We call her Chris. She's the owner of Brevard Mediation Services, and she's been in practice as a full-time neutral since 2011. She's a certified mediator, certified in all areas except family and dependency. She's also a Florida qualified arbitrator. She is former chair of the Florida Bar ADR section, and in that role, she co-founded the groundbreaking Mentoring Academy for Mediators, and it is a fabulous seminar. She's also a member of AAA's panel for mediators and arbitrators in commercial and employment matters. So let's give our panel a warm welcome. And now I'm going to turn it over to Lawrence.
All right, so next slide. We had a discussion among ourselves in the ADR Executive Council section, and we've basically said, you know, we need to get on top of this stuff. And you might have seen there have been a few presentations already by our section and others, and we just said, how are we going to get on top of this? And the best way to do it is give a webinar, because you got to learn the stuff to give a webinar. So Obviously, it's the hot topic. Everybody's talking about it. The daily news cycle is full of it. And we know a little bit about it because we've been playing with it. I know I've been, messing around with ChatGPT, the DALL-E illustrations. You got Bard and Copilot with Microsoft, and we're starting to get into these products and see what they can do for us, even on a daily task level. But then we say, what can they do for us in mediation? And so this is really the purpose of it, is to kind of give a broad overview. None of us are experts, none of us code, but we have familiarity and facility with some of the products, and we're giving our best at the moment advice. Next slide. So everybody is familiar with the lawyer from New York who has been, I think, since fined $5,000 along with some of his colleagues for using the ChatGPT without having any jeopardizing or any checking of information and submitting it to the court. And so as a result, obviously a backlash immediately, and to many of the lawyers, a cautionary tale for presenting something that it turned out to be a hallucination or a bogus site. And these, I think, was an aviation case, and there were several sites that just didn't exist. And he had to write apologies to judges even that were cited in the opinions that didn't exist for having cited fake opinions. So, we're looking at how is this, going to work out in terms of using things and having the ability to rely on them. All of us on the call here have familiarity with using research tools through Westlaw, Lexis, and the like. And of course, those of you that are reading the headlines saw that Case Text was acquired by Thomson Reuters, and they have a co-counsel product, and Jurisage and SiteRight have merged in Canada, and there's something called Super Legal and Legalizer, Smart Contract. So all of these things are being marketed to us, and how do we know that we can trust them and use them with our clients and use them in the process of ADR? And we just don't really know yet, so we're trying to learn as much as possible. We know that we started with plain language and Boolean searches back in the day when dial-up was necessary to access LexisNexis, and of course now we have things that are so product design that they're opinion minding and predicting outcomes, and content creation for even the backside of law firms. So next slide. What is AI? Is our question, and the subset that we're really dealing with is the machine learning. So it's something that is really emulating what humans do, but when you put it through the analytics and the experience learning, the computer looks at patterns and looks at the world and the data, the text and images that it's fed, and they can process those images and those data and those points faster than any humanly capable person, so that the thought is, will this enhance or augment our ability to do the tasks that we do every day and in our profession? And so we're looking at, how is it that this tool can be used effectively as a sidekick? And so one of us will be giving sort of the pros, and then I chose to sort of be the contrarian of the group. So later we'll discuss how that the negatives of why AI is a danger at this point. And so with that, I'm going to turn it over to one of the esteemed panelists on what is used currently in ODR, which is what we call online dispute resolution, which has a couple of definitions. But Christy, you want to tell us about that?
Yeah, definitely. So online dispute resolution, known as ODR, has actually been around since the 90s, and it's a really broad term that basically encompasses anything that uses the internet to help facilitate a dispute resolution. So it can be everything from automated negotiations to using Zoom for a mediation, which I like to call e-mediations. It really has a very broad applicability there. So the basic idea behind ODR is that this was kind of started by eBay in the 90s. And what they did is they set up a system where they could create a structured dispute resolution mechanism between buyers and sellers so that they could quickly resolve disputes between them. And it was as simple as, clicking on the type of dispute that you have and communicating via essentially email at the time with the person you had a dispute with to try and get things resolved. And it has since evolved. You know, you've got other forms of ODR that use kind of automated chatbots and things of that nature. But the basic idea is that you can use the internet to help you either communicate with the other side or have automated negotiations. You actually have programs that will go ahead and allow parties to say, hey, this is my high point, this is my low point, and based on that, the program will figure out where an ideal settlement would be for both parties. There are hundreds of different programs out there that try to assist with ODR in various different ways. And we've seen this play out in court systems as well. So next slide, please. We actually have this in all sorts of different places throughout the world. Europe is very well known for its European ODR platform, which is used to help resolve consumer disputes in the EU, Norway, Iceland, and Liechtenstein. And it basically helps the consumers and the traders to communicate with each other, have an online first meeting, and then if that meeting doesn't work well, to use other online negotiation tools to try and get things resolved. Canada is also known for being a leader in essentially e-mediations and ODR platforms that help with automated resolution of cases. British Columbia in particular was known for implementing this system in their courts where people could log in and they could choose to have kind of an online negotiation with the other side to try and get their problem resolved. And it ended up being quite successful. And that's actually something that Florida did a pilot program of recently. It was actually right around the time when COVID was starting that Florida was trying to do this. And Florida ended up having well, I should say not Florida as a state, Orange County specifically had approximately 1,600 small claims cases go through that program. And I will say from the data I've researched, about 1,000 of the cases did not end up using the program because there were requirements that people respond in a certain amount of time and they didn't respond in time. So they kind of timed out of the program. But of the 613 cases that did use the program, 344 of them settled. So we saw approximately a 50% settlement rate. Not quite as high as I think you would usually find with an in-person mediator, but considering the parties were essentially emailing with each other in order to try and negotiate a settlement, you know, it actually at least got them communicating and got them to a settlement in more than half of the cases.
And that was my experience with that program, the Tyler program in Orange. Is I helped a party through it, and then there was a lack of response. And once the time, as you said, timed out, then it went back to, hey, can we have a person mediate your case?
Yes, that's definitely the biggest, I think, obstacle to some of these automated ODR platforms is that they'll give you a timeline, right? Like 3 days in order for someone to respond to you. And if they don't respond in this messaging tool that you're using, which essentially functions kind of like email, the case automatically times out. So as we saw, a lot of people did not respond quickly. So 1,000 of the 1,600 cases timed out. So definitely an issue that needs to be addressed when you're dealing with ODR platforms as opposed to in-person or even virtual mediations with a human mediator.
Next slide.
Terrific. All right, everybody, this is Chris Magee, and I get to talk about some of the ways that AI has been used and it continues to be used, even before we had all the excitement about Chat GPT. Next slide, please. I want to talk a little bit about CyberSettle, which is sort of a granddaddy. I know Christy referred to ODR and the eBay program, but CyberSettle has made great inroads and was developed all the way back in 1996, which feels like a lifetime ago. and was marketed to primarily personal injury lawyers and insurance carriers as a way to utilize an algorithm. So the premise on which CyberSettle rested, and still does rest today, is that experienced claims adjusters, experienced plaintiffs counsel, and experienced defense counsel know what the relative value of a particular injury is if they've been doing this long enough. And so what CyberSettle proposed is that each side could institute 3 offers. There'd be a low offer, a medium offer, and a high offer. And that if any of those values and any of those offers were within 20% of each other, CyberSettle would split the difference and reduce the high value by 10% and increase the low value by 10%, and the case would be considered settled. So there's a lot of pros for this and also a lot of cons. So in personal injury cases or single issue cases, CyberSettle works very well. It's easy to engage with. They actually have human beings who will call you and say, oh, you know, there's some offers waiting for you to respond to, or conversely, there are some demands waiting for you to respond to. And so they kind of help all the parties get engaged and get into the program. And that seems to lead to some of their success. Of course, the cons are that if you are looking for any kind of relief other than monetary relief, the program is not particularly useful or good at that. So if you think about an employment case, if you're looking for injunctive relief, or you're looking for a return to work kind of relief, or you're looking for something other than just dollars and cents, very difficult to do. I'm going to stay on the employment example for another minute, because even if you could come up with the value of what a wronged employee should get from their former employer, you still have that whole issue of attorney's fees to deal with before you can successfully resolve the case. So those are some of the ways that CyberSettle was a little deficient, but it has been very, very helpful. What's interesting to me is that CyberSettle reached a point where they said, if you can't settle the case with this double-blind 3-offer kind of model, we'll supply you with a person who works for us who can help you reach that resolution. But of course, that opened up so many ethical concerns, right? Is it actually the unlicensed practice of law? How do you have people helping individuals who are in dispute reach a resolution without calling them mediators? If you call them mediators, now you have to deal with certification issues in the states that require them, and on and on and on. But it was very useful, and as I said, it could be quite successful in those single issue, definite dollar cases. Next slide, please. I want to talk a little about this one. This is another, I'm not sure how prevalent it is any longer, but for a while it was a prevalent use of an algorithm in the criminal context. So COMPASS is actually an acronym for a mouthful of a program title, which is the Correctional Offender Management Profiling for Alternative Sanctions. And it gets used, or was used, to the extent that it continues to be used, in helping judges decide during arraignment whether a criminal defendant is a flight risk, and at the other end of the process, when offenders are up for probation, whether in fact they're at a risk of recidivism. So some of the issues that have come up with COMPASS are that it's difficult for parties who are criminal defendants to address some of the issues that COMPASS presents. You can't cross-examine an algorithm. The algorithm is public except for the proprietary portions of it that they consider that they call weighted factors. And so if you are trying to defend someone and you're trying to find out whether or not COMPASS has taken the right approach with the data about this person that they put into their formula, you hit the brick wall. You can't tell what they're doing or how they're doing it. So of course that opens up constitutional challenges, equal protection, due process, And there's also been a lot of allegations that Compass is not narrowly tailored. So one of the things that Compass said when they were embarking on this program was that Compass is better than a human decision maker in this very sensitive area of depriving someone of life and liberty and the impacts that it's going to have on their family, because Compass doesn't have the bias that a human decision maker would have. Compass doesn't consider race. Compass doesn't consider income level. Compass doesn't consider gender. Compass does all of what it does outside of those extrajudicial factors that it assumes that human decision makers include in the process. So I have up here whether there's bias in the AI or not, because as Lawrence referenced, sometimes what takes place within the scope of the development of the artificial intelligence actually ends up feeding bias into the system. So that was the first part. I have the hungry judge reference here because there's sort of this apocryphal story about the fact that when a judge gets to the end of the docket, assuming they start at 9 a.m. and they're closing up for a break at noon, that there seemed to be evidence to support the fact that the judge would go faster, be more brusque with all the parties and participants, and not spend the time necessary to determine with the same degree of care that the judge appeared to be using at the beginning of the docket session. But it turns out when they went back to try to replicate that concept or to see if it was actually true, they couldn't find any statistical evidence that would support that concept. So the idea that the judge is getting hungry, so the judge is rushing, so the judge can get to break time and get a minute to have something to eat or drink before diving back in, doesn't appear to be substantiated. But again, that just does beg the question, if your decision maker is relying on extrajudicial factors, whether that decision maker is either the algorithm or the individual, you're going to have a problem with the system, and that's what needs to be addressed. I'll have the next slide, please. And there was also a reference made a little bit early in our presentation to this idea of predictive analytics. So we've seen this at Lexis and Westlaw, and there are other programs that are out there that are saying similar things, that they have the information that will enable you as an advocate to decide whether it's worthwhile to file a motion, because they can give you an inkling of what the outcome of that motion may be. So we could have a long conversation about whether that is accurate or not accurate. We could have another long conversation about whether it makes sense to file a motion or not, even if someone gives you a hint as to what the outcome would be. But the conversation that I wanted to have about this concept is what it implies for mediation. I think one of the primary benefits of mediation is that when you as an advocate sit down with your client and the mediator and start reality testing some of the assumptions that the party has or the lawyer has about what's going to happen in a particular case, that's where you really begin to offer the parties the education they need to make that ultimate decision about whether it makes sense for them to change their position and whether and how to move in order to come to the endpoint in the process that they're seeking. So I think if you were just going to have that conversation with the computer and say, well, you know, if I file this motion for summary judgment, I'm only going to win it 4 times out of 10, so maybe I won't file it. I'm not sure that gives you the same benefit and substance that you're seeking when you sit down and you talk to a mediator about that. How many times have lawyers wanted the neutral to fulfill that role of really educating the party about some of the risks and benefits of staying in the process versus reaching a resolution during the mediation session? And lastly, but certainly not least, is that when a mediator sits with you and your client and talks to you and listens to you and shows all the respect that's due to you as you're working your way through what the process is, I think that reinforces and validates for the client that they picked the right person to represent them. And I think that that is also an invaluable benefit of going through the mediation process. So I'm not sure that predictive analytics are going to have that much of an impact on the mediation process, but that concept is certainly out there. I'll take the next slide. So one of the things that we wanted to share with you is this idea that there are algorithms that predict behavior, right? So one of the science.org in 2017 created an algorithm, and it used the algorithm to assess the outcome of the 2017 Supreme Court docket. And lo and behold, the algorithm had correct predictions 70% of the time, whereas the predictions of the most experienced human court watchers only came in at 65%. So, you know, nobody made too much about this except, well, it's out there and maybe we'll use it. The interesting thing to me is that science has not tried to replicate this since 2017, or if they have, they haven't published on it. And there hasn't really been any effort to corroborate or to utilize this kind of algorithm again in this context. I'll take the next slide.
All right, thank you, Chris. I enjoyed hearing about the predictive analytics. I'm going to touch on that myself. So compared to many other professions and industries, the legal field has actually been historically slow to accept technology. So I did a little searching around on the internet, and I stumbled across a 2018 Forbes article titled "Lawyers and Technology, Frenemies or Collaborators?" I'm going to read a short quote to you from that article because I think it is quite informative. "Technology is transforming every segment of the legal ecosystem, including its workforce, division of labor, economics, structure, providers, skill sets, career trajectories, education and training, customer expectations, and culture." The author says that while consumers of legal services welcome the change, most lawyers do not. Technology has upended predictable career paths and is recasting how, for whom, with whom, and on what terms many lawyers will work. In short, technology is changing legal culture and what it means to be a lawyer and maybe what it means to be a mediator. Now, keep in mind that this was written in 2018, and do not despair, lawyers are still going to have jobs, but I think you can look around within your own office and see how technology has changed the way you do things, particularly if you've been in the practice of law for a very long time. You can see that. Think though about the pandemic. When I think about how resilient we have been as a profession, when the pandemic first came, I said to myself, okay, I gotta go find something else to do because I'm obviously not gonna mediate cases anymore. But it was only a few months before our firm started doing video conference mediations on Zooms. And then of course, you had the same thing with the court system. Hearings, trials, etc., all went to video conferencing. And the current statistics reflect that most mediations occur by video conference. And there are only a small percentage that are now taking place in person. So let me, after doing the doom and gloom here a little bit, let me talk about what I see as some of the advantages of using AI in the legal field and in mediation. So next slide, please. Processing. This is amazing to me, okay? AI has tremendous processing power. AI can process data with remarkable speed. There are tools out there that can be used to examine 2.7 million documents in relevant content, or I'm sorry, for relevant content in less than 2 hours. Now let me state the obvious. Human brains have limitations. We get tired, we get hungry, we have emotions. We are not computers. And we've already seen AI being used in various forms and fashions with electronic discovery, better known as TAR, or technology assisted review, or sometimes called CAR, computer assisted review. So the way that in essence works is the data is collected, it's filtered, it's organized, it's analyzed, and through natural language processing, a system identifies those words and phrases that might be important to the lawyer and prioritizes them. Parties then have the capability of searching for those terms, isolating data according to those terms. Now, let's face it, there's no doubt that computers are more efficient at this function and sometimes more accurate as well. Algorithms can process data at high precision with minimal cost. Next slide. Of course, AI also has the capability of analyzing massive amounts of data more efficiently than the human brain. AI has the ability to detect correlations in large data sets that no human could do. What a remarkably useful tool for complex commercial litigation or mediation, where parties provide large numbers of documents that may or may not be relevant to the issues in a mediation or in the litigation. AI can certainly assist in categorizing these documents. And in my review online of the different sources that are available, the different AI sources that are available to lawyers, I found AI sources that could review documents, search databases, do legal research, we're all aware of that, draft documents, be responsible for contract compliance, extract information, and there are certainly programs out there to assist not only in the litigation area, but in the transactional as well. Next slide. So artificial intelligence has been applied successfully in thousands of ways, but one of the less visible ways, and really probably one of the less dramatic, is improving data management. So there's really 5 common data management areas where AI plays a role. Some of those are applicable in mediation and litigation, some not so much. Classification, and this would include obtaining, extracting, and structuring data from documents, photos, handwriting, other media. Catalog.
Michelle, we did that as special magistrates for like months on end because we were assigned to find the hot docs even as neutrals, and wondering how that could.
You know, Lawrence, I'm glad you brought that up because I had completely forgotten about that. Totally forgot. We spent hours doing that.
Yep.
Interesting. Okay. Cataloging, helping to locate data and categorizing data. Quality, reducing errors in data. Security, keeping data safe from bad actors, and ensuring compliance with laws, policies, customs. And then data integration, which is building master lists of data. And then of course that would include merging those lists as well. So what about an AI system that could analyze interconnected issues and identify solutions that maybe a mediation participant could not otherwise realize? Would that not be useful in multi-party disputes where you've got claims, cross-claims, counterclaims, third-party claims, and in addition to that, multiple avenues for resolution? Next slide, please. So here's an area where I really think AI could be quite useful. You know, a lawyer can draw upon AI resources to prepare pleadings, conduct research, to prepare a mediation summary. It can certainly assist attorneys in reasoning and also language choice. So I'm going to steal your thunder a little bit here, Chris, but just for fun, Chris asked ChatGPT to prepare an outline for her on another presentation. She shared the work product with me, and it was a decent outline, but it did not meet the needs of her particular presentation. It was far too general, but I thought that was pretty interesting to see the type of outline that ChatGPT prepared for her. And the most important thing I would recommend with regard to using AI for preparing documents or summaries, you've got to check those sources like Lawrence and Chris talked about, and your documents need to be reviewed thoroughly for accuracy. So you've heard about the horror stories of lawyers using AI for a work product and then not checking sources, not checking citations, according to Lawrence, not even checking to see who the judges were. So AI programs can suggest multiple possibilities for problem solving, and they could be useful to a mediator when brainstorming multiple options for resolution. Next slide. So we already talked about this. I want to talk about it a little more with respect to the role of a mediator and the use of predictive analytics, which is really what it's called for mediators. So the two programs I came across were Lex Machina and Ravel Law. And Lex Machina is touted to provide early and individualized case evaluations. And Ravel Law is just a public case access site that was a collaboration between Harvard Law Library and Ravel Law. And that particular AI offers access to millions of cases published and unpublished back to 1658. But I can see that predictive analytics could be very controversial in the mediation context. Do you really want your mediator to utilize AI and predict the outcome of your case? And I have read some law review articles that suggest that's a good use of AI. I really question that. Does it affect the mediator's neutrality? Is it even ethical for the Florida mediator to provide an evaluation? So I ran the idea by a group of 20 or so employment lawyers who said they would certainly not want me as their mediator to provide AI predictions on case outcomes in mediation. And one of the things that occurred to me while listening to Chris is just because you can have some probabilities about what might happen with respect to a particular motion, a trial, something of that nature, that doesn't tell you exactly what could take place within this particular trial or this particular motion in the context of this particular case. You know, in some respects, I view cases almost like real estate. It's very unique. Each case is very unique, and so you can't necessarily just lump it into some kind of predictive analytics. Next slide. So I think one of the most significant benefits of AI in the legal system is the one you've already heard about with Christy, and that's ODR, right? And that's been effective, at least to some extent, for resolving smaller disputes. And we all know as lawyers that there are certain types of disputes that really don't merit legal representations. They're valid disputes, they need resolving, but they're really not the type of cases that are appropriate to bring in lawyers just due to the cost involved. And so AI can assist in providing access to justice for people who can't afford lawyers or just determine that it's not appropriate to use a lawyer in a particular type of case. So that can also reduce the strain on the justice system. and allow disputes to be decided probably more efficiently and without the involvement of humans, whether they're judges or arbitrators. Next slide, please. And you heard Lawrence talk about this. So, you know, there is a suggestion in the literature that AI is more objective, and Chris talked about this too, and therefore less subject to human bias. And there's also a suggestion that AI is not going to be subject to implicit bias. Just FYI, implicit bias is a form of bias that occurs automatically and unintentionally, but it still does affect people's judgment, their decisions, their behavior. But, you know, one caution, keep in mind that behind all the coding in the algorithms are humans, and their biases could consequently come into play on how data is labeled, processed, categorized, and that type of thing. So in summary, I want to kind of go through with you the advantages before we turn it over to Lawrence and he tells you about all the disadvantages. So, sorry, Lawrence.
Hashtag Team Human.
Yeah. So we've got the advantages are speed, efficiency, accuracy in some respects, data processing and management, problem solving, and potential freedom from bias. All right, Lawrence, have at it.
I'll give you one more bone on AI being considered apparently less judgmental from a product that Microsoft tried in China called Xiaoice. It's Xiaoice, and it was some kind of personal companion that people downloaded on their phone and could converse with, sort of a chat bot. And I guess when dealing with psychological issues, at least in the study that I think USC performed, they found that people were more honest with the AI than an individual counselor. So that's kind of an interesting thing. But yes, I am here to sort of rain on the whole parade at the moment, because I feel like this is just a moment in the thousands of year tradition of mediation, getting people together, you know, solving disputes and moving on with life. And I don't know that this is, you know, an appropriate tool, but I don't think it's going to replace the human aspect. So what I say here is that, you know, it's sort of an intruder in the process, and it perhaps can compromise our neutrality because we might bring to it things that maybe affect one party, benefit one party more than the other, and we're not always sure that the information is correct. And then what are they really hiring? They're not hiring a computer algorithm, they're hiring a person who understands conflict and can be a quick study about the dispute and read people and get people to make concessions and move on. So the human experience of the mediator is what you're paying for in the process, and hopefully the outcome resolves in a settlement. Next slide, please. So I think in looking at lacking of trust, and I mentioned the one study, but you know, there's, I think, a artifice to the human emotion side. I mean, I even think my virtual assistants around the house, and then I think, what am I doing? A person isn't in there. There's just a program. Do we treat people with respect and computers with respect? I don't know. There's also a code of ethics being proposed about AI, and you know, things that typically would be encompassing of human behavior are they also applicable to the computer? So this idea that it can develop some emotional component, I think that's there, but does a mediator have more empathy to connect with a human in a conflict situation? Likely. Does the human have more emotional intelligence, like the power of persuasion or reasonableness or showing caring? And is the tool, you know, really going to replace that and sort of convincing a human to do something to get them past an impasse? I don't know yet. And so until we find sort of the intuition, and I think that comes with what I mentioned in the early slide, the singularity, the artificial general intelligence, the computer thinking for itself, thinking on its feet, and we're not there. But what's scary is, you know, we're in this period where I guess we're on the eve of Chat GPT-5 before the end of the year, apparently. And by the way, GPT stands for Generatively Pre-trained Transformer. That was sort of the nickname given to it by OpenAI as they developed it and were impressed by the results in every iteration of it. And so, as you know, we can go to the next slide. We have been an audience to a letter of, hundreds of people in technology that are worried about how fast this thing is learning, and will it get ahead of us and be too clever? And of course, you see references to the Terminator and things like that, Skynet, and I don't think anybody thinks it's going to happen overnight, but is it a point where that ability to think faster is really compromising human behavior? So we're looking in now is, how to scale these things in an appropriate way that doesn't get away from us. You saw government officials attending the DEF CON hacker conference. The FTC is looking at regulating this, and last month they filed a suit against automators out in California. They even got a TRO, because when these significant changes happen, they bring bad actors with them, and they have people out there giving unsubstantiated claims of what the AI will do. And so you're looking at DOJ and the Consumer Financial Protection Bureau and EEOC and all these agencies. What can they do under their purview to protect the public, to promote the safety of AI? And perhaps with those regulations will come maybe a little more trust in the ability to use that. You're also seeing, because of the famous case we mentioned and other things, a self-reporting duty. So a lot of courts are going to, if you use AI, inform us that you did, or universities, Christy and I teach at UCF, they're told us what to use to find out if our students are using AI, and to try and encourage them to learn it but not lean on it and use it as a form of academic dishonesty. So, and it's getting harder and harder to tell what's human and what's generative. So these are all things that we're dealing with outside of the profession, as well as bringing this into the new ADR field. Next slide. We also have to worry about privacy, right? Confidentiality and mediation. And we're learning from our friends in the healthcare sector that you have to look at, controlling PHI and things like that for HIPAA. And can it be done? And can it be made where you're feeding it de-identified information and using those outcomes in maintaining that confidentiality? So all this remains to be seen, and it's tricky, and we're working on utilizing it in a responsible way. And I also don't want to run afoul of the bar, and the bar has actually created an AI committee, and so they're looking at this too. So it's all very early days. Everybody needs to use caution, but get familiar with it so that you're not left behind. Next slide. So we talked about in the beginning, what is the way that this stuff works? You have to fill it with something. You have to put something in to get something out. And so, of course, as we've heard about technology from the onset, garbage in, garbage out. But the thing is, this thing is learning from each time. So when it makes mistakes, it learns not to do it the second time or the third time. And so this prompt preparation, of course, has become a huge it's really a profession now for the moment, until the computers get smart enough, how we want to get the outcome from it and what that outcome is going to be. As Michelle mentioned, predictive analytics is part of the reason for having this around. So I was actually in a mediation the other day, and one managing partner at a large law firm told me that they had fed ChatGPT with the facts of cases that actually had gone to verdict, and the AI was way off on how those cases would come out. So that was sort of a tiny but real life sample fed in, and then what came out was anathema to what happened in the jury. And it's interesting, and I think that's just playing with it. You might see the weaknesses of it. I used it to write an insurance demand letter to my own carrier, and it was pretty good. I could probably sign my name. But it's interesting. What it spits out isn't always the right thing, and of course it could make up stuff, and that's also what we're being wary of. Next slide.
Just real quick on that note, ChatGPT in particular is about 2 years behind the times. So if you're asking it about anything, like any recent verdicts or changes in the law, like our tort reforms that we've had recently and things like that, it has no idea about any of that.
That's a very good point. Yes, it is behind the times on the information that's contained in it. And of course, there's being right now prosecuted several lawsuits saying that, you know, it's infringing on copyrights, it's taking text without permission, it's doing all this stuff. So we'll see how those shake out as well in our ability to use the universe of information out there in order to get the results that we're looking for. So in terms of mediation, looking at self-determination, you know, people need to figure out what works for them. They don't want, they're at the mediation because they don't want a court to tell them what to do or a jury to tell them how it comes out, or a motion to slash them at the knees. So basically, you know, have this idea of talking about solutions and exploring them with the parties and facilitating that resolution. But if you're bringing the AI in there as this interloper, could that be compromised? That's one of the things we'll talk about in the ethics part that Christy will get to. And in decision making, you know, it might follow, and I used to use that CyberSettle app just as a curiosity. I'm not even sure it's on the App Store anymore, but I would put in the moves and just see what the little graph would tell me was realistically the settlement point. And sometimes it was a way off. So you don't know what is driving somebody to make that decision to come in from the cold and reduce their demand or get to the point where, you know, you're overlapping. And so it is interesting and it's informative, but it's not the end all be all. And so until we're at that sort of goal of AGI when something can be smarter than we are, I don't know that we're really going to be able to rely on it. Next slide. This is one that is kind of funny, but you know, sometimes things just happen at the same time. They're not correlated. They're not really because there's more ice cream that month, there were more shark attacks or whatever. It's sometimes that same thing where the output is rarely optimal. It doesn't make any sense. Just because the stats and the data are fed in and it finds a correlation doesn't mean there's really any cause to it. So just a sort of cautionary slide here, and looking at, you know, things that coincide don't always mean that they're related. And then the next slide, please. So in terms of our interpersonal touch, I think I mentioned this. I just feel like there's things that happen that we give our insights, that our relationships with the lawyers and the parties, even sometimes the rapport that we build, these areas that just can't be replicated at the moment by AI are why we still need a human in the process. And so perhaps there will be a time when, you know, we can rely on a machine to, you know, knock heads together, as it were. But I feel like the self-awareness, the ability to turn on a dime that many of us have just by experience in the process is lacking at the moment. Next slide, please. And this is a shout out to Chris Magee, who, like me, was a fan of the Max Headroom on HBO. But you know, wrinkles occur, and Max, he didn't really get things all the time. I mean, it was a character in a computer simulation, but still, you know, the idea that context is everything. The AI doesn't always appreciate what's going on, the other factors. It may be able to think 2 moves ahead on a monetary negotiation or something like that, but the aspect of what's driving that, you know, 2 partners in business that are splitting up, a physician and a practice, you know, an author and an illustrator, you know, these kind of things can't be appreciated by that black box just yet. So that fluidity in the creativity and things that are required of a good mediator, you know, we're saying still we're necessary, we're not going anywhere, and yes, we're open to utilizing these tools as they become available to us.
So Lawrence, I just wanted to jump in for a second because you invoked my name, but how many times in mediation do we talk to the parties about the process? Trust the process. We're going to get to where we want to, as far as we can go, but we've got to work the process. And algorithms are a bit more clinical than that. They're a little bit more formula driven. They don't really, they can't really get in and work the process the way that I think that the human interaction with a mediator can do. So, will we ever get to that point where it can be the process? I'm not sure. but I do feel like there's a huge gap at this moment.
And we're also the guardian of the process, right? I mean, there are boundaries, and we don't always bump up against them in every case, but there are instances when you need to terminate a mediation, and is the computer going to do that? So it's can a computer say, let's come back another day? I don't know. All right, on to the ethics in our last 5 minutes here.
So we actually have a lot of different ethical issues that impact the mediators and the lawyers. Here in Florida in particular, mediators have strict ethical rules that they need to follow, just like lawyers do, as Lawrence was kind of just saying. And so, of course, mediators have to remain completely neutral and have to respect the party's self-determination. Those are definitely key principles of mediation. And those are things that it can be challenging for a computer program, an AI program to accomplish, right? Lawrence was just saying, will a computer program, will an AI know when party self-determination needs to rule and a mediation needs to end, because that's what the parties want, or if it needs to be continued. And as Michelle talked about, even AI programs can actually have implicit biases based on how they're created. So neutrality can actually be a concern with AI. But the other thing to keep in mind is that if a mediator is using AI in order to try and figure out where exactly a case should settle potentially, that can actually then bias the mediator into thinking, oh, well, one side needs to come up a lot more, one side needs to drop their number a lot, something like that. And so it can actually be dangerous for mediators to use AI in that particular way. But from a legal perspective, for the lawyers who are involved in the cases, it can also be dangerous to use AI if you're not using it responsibly. So, of course, as a Florida bar member, we're all bound by Rule 4-1.1, which is legal competence. And in Florida, we actually were one of the very first states to say legal competence includes technological competence. You have to be prepared to understand any of the technology you're using. You have to know what technology is out there and be using it appropriately. And that's something that, we're really seeing with AI right now. If you are not familiar with how AI works, or whatever AI platform you're using works, right? Like ChatGPT, which is a language learning platform. If you're not familiar with that and you don't understand it, like that lawyer in New York, who clearly did not understand it was not a research tool, you are actually violating bar rules. So you have to be very careful with that. You also have a duty to supervise any of the people or processes you use as a lawyer. And that includes supervising the tools you use, like AI. So that's Rule 4-5.3 under the Florida Bar Rules. And that's something to consider as well. You have to supervise whatever information the AI gives you, which means you have to review it, you have to check it over for accuracy. And Lawrence, I believe, mentioned that earlier when he said a lot of courts are having lawyers now say, hey, I used AI for this portion, I double checked it's all correct, so you should still accept my brief, kind of thing. Next slide, please.
Chris?
Hey, Chris, tell us what your ChatGPT concluded on your inquiry.
So I'll just do this really quickly. So I did put into ChatGPT a pretend negotiation, right? And I said, look, the demand is $1.2 million. First offer was $250,000. What is the next demand that should be made from the plaintiff's perspective? And ChatGPT gave me all the factors that ought to be thought about. You got to think about the value of the case and how much do you want to get rid of it and all those kinds of things. So then I went back and I said, again, I asked ChatGPT to make my prompt just a little tighter and said, here's what the offer and demand history has been so far. Do you think that my next move, going from $250,000 as the offer to $500,000, is the correct move? And ChatGPT said all the same things that it said in the first answer: know the value of your case, understand the dynamics of the parties. And then it said, go get a mediator, because a mediator is going to help you resolve this better than I can. So I thought that was worth a shout out.
Words to live by.
Yeah, you have to love that, right? You have to love that for sure. Well, here we are right at 1 o'clock concluding. Thank you for your patience in joining us today. And if you are a Florida attorney, jot down the Florida Bar course number. I'll read it for those of you who might be participating by phone and not by video. So the number is 2308307N. 2308307N. So we are in the process right now of building our webinar schedule for the remainder of this year and the beginning of 2024. So do keep an eye on your email inbox for news about our future programs. And on this slide, we've got some contact information. So feel free to email us. And we've gotten some questions by email, and I don't know, panel, what do you think? Do you want to try to break those up and answer those, or do you want to offer ourselves at another conference time to answer those? What are your thoughts?
Yeah, I think we can get back to them. We had several that we had hoped to address and ran out of time. But yes, we'll be available to your inquiries.
But thank you for your attendance, and we'll look forward to seeing you at future webinars.
Thanks, everybody.
Thank you.
Thank you all.